Did you enter the United States with a fake document and now you're married to a US citizen and you're wondering, can I file for my green card? I'm going to talk about that in this video. My name is Ashley. I'm an immigration attorney. I've been practicing immigration law for nearly 13 years. I have two office locations, one in Carlsbad, California, and the other in Bend, Oregon. However, because I only practice immigration law, which is federal, my office is able to help clients who are located all over the United States. So in this video, I want to talk about the situation when somebody enters the United States with a fake document and they are then later on, they get married to a US citizen and they're wondering if they can file for their green card here in the United States through the process that is called adjustment of status. So briefly, I'm going to talk about the legal requirement for adjustment of status, and then I'm going to talk about what it means if you have entered the United States using any kind of fake document that didn't belong to you or that was wrongfully issued to you. So the main requirement for adjustment of status, if you are married to a US citizen, is that you have a lawful entry to the United States. So that means that you were lawfully admitted at the border by an immigration official. Now, there are other requirements for adjustment of status, but for purposes of this video, that is the main requirement that we are going to be talking about as it relates to entering with a fake document. So under the immigration laws, even if you enter with a fake document, it is considered to be a lawful entry because you presented yourself at the border and an immigration official allowed you to come in. That's to say that you didn't enter hidden in a car where you were not seen by an immigration official. You didn't enter, walking through the hills, around any kind of port of entry where you were not caught by an immigration official. You literally went to a port of entry and you showed a document that was not yours and you were allowed to enter. So you have satisfied that requirement that you legally entered the United States. However, because you entered with a false document, you will require a waiver. Now, this waiver is what's known as a 601 waiver. This is a waiver for somebody who has committed some kind of fraud or made any kind of misrepresentation as it relates to immigration. So, for example, entering with let's say a fake kind of visa, that had your name, but it was fake, that you presented, like say a stamp and a passport that was not legitimate. The immigration officer didn't catch it. They allowed you to come in. You would need the fraud misrepresentation waiver. If you entered with, let's say, a green card that didn't belong to you, the person really looked very similar to you, the officer glanced at it, didn't really look at it, too long, and they waved you through. Okay, again, you're going to need that fraud misrepresentation waiver. Now, you may be wondering, but why do I need this waiver if I was allowed to come in with this document, right? The reason why is because when you go to file your adjustment of status, you have to provide immigration with proof of your entry. They want to see, how did you enter? So what that typically looks like is somebody providing a stamp on their passport that they received. It can also look like if they happen to have if they're from Mexico, they happen to have a border crossing card in their name with their photo, they can present that. And also sometimes people use their history of entries and exits, which can be looked up on the CBP website using, again, their true information. So typing in their passport number, their name, their date of birth, and then you can search your entries and exits. And oftentimes there will be a history of that can be printed out and included with the adjustment packet to show USCIS when your last lawful entry was. So, of course, if you have entered with a fake document, you are not going to want to present that document with your adjustment of status filing and hope that immigration is not going to question it at that stage, because they absolutely will. They will see that that is not your document and they will find out that you have made this misrepresentation, which is why you need to file the 601 waiver. So the 601 waiver requires that you have a qualifying relative. A qualifying relative is a US citizen or lawful permanent resident spouse or parent. So if you are married to a US citizen, you've got your qualifying relative right there. You qualify to file this waiver. The waiver requires showing immigration how your US citizen spouse is going to suffer extreme hardship in a variety of ways if you are not granted your green card. So, this means that you need to show immigration with evidence of how your spouse is going to suffer financially if they have any medical issues that require them to be receiving care in the United States. You're going to want to provide evidence of that. You're going to want to provide evidence of how they would suffer emotionally. So, evidence of their ties to the US and why they can't just uproot themselves to go live in your home country, what kind of emotional impact that would have on them, perhaps from not being able to see family members and friends in the United States. They want to see evidence of reasons why your US citizen spouse cannot go live with you in your home country. So, conditions in your home country. What are their job prospects going to be like in their home country, in your home country? Are they going to not have a lot of job opportunities there because they've never lived there, they've never worked there, they don't have any employment history there? So, there's all sorts of factors that immigration is going to be looking at to decide whether your spouse would suffer extreme hardship in these different areas. Something important to point out is that immigration needs to see hardship that is above and beyond what any couple would normally experience from a separation, which means that you really need to make sure that you have a compelling case with the right kinds of evidence. Often, this includes a declaration from not only you as the intending immigrant, but your US citizen spouse that talks about your relationship, your lives in the United States. If you have children together, you definitely want to factor them into this, even though they are not considered to be a qualifying relative. They are relevant in the sense that they do contribute to the hardship that your spouse would experience if you were not allowed to stay with your family in the United States. For example, is your spouse going to become essentially a single parent to these children if you are not allowed to stay here? And then how is that going to impact your spouse? So, my recommendation is that if you need to file this waiver, that you absolutely have an immigration attorney to make sure that your specific facts are presented in the best light possible. Because again, immigration requires more than just the usual hardship that any couple would experience if they were separated. They really want to be seeing things that are above and beyond what would normally happen to any couple from a separation, which is why you want to have an attorney who has experience filing these waivers, who knows the best way to present certain types of information, who knows what kind of documents you want to have for each category of hardship: financial, emotional, health hardship, reasons why your spouse can't relocate to your home country. So this is all information that an experienced immigration attorney can help you to understand, and they can help you organize a very compelling waiver packet for submission with your adjustment of status case. All right, so finally, should go without saying that my office has filed many of these waivers successfully, and so it would be our pleasure to assist you if you find yourself in this situation where you have entered the United States unlawfully, or sorry, lawfully, but with a false document, and you are now married to a US citizen. Please don't hesitate to reach out to us about this case. We have a lot of experience handling these cases successfully. Don't forget to like and subscribe to my channel. And if you have any questions, contact us at 760-812-3778.